Okay, it's going live. Okay, it's going live.
Let them in.
Yes, please.
Hi, Judge. Good afternoon.
Good afternoon.
This is Tim O'Connor.
Okay. From Houston.
Yes, ma'am.
Okay. Mr. Side, you're still on mute.
Good morning, Judge. Sorry about that.
How are you?
Good, good, very good.
Hi,
Good.
Mr. Scott. How are you?
Now, Mr. Moose, now, Mr. Side, you're arguing the motion, correct?
I'm gonna argue the motion, yes, ma'am.
Okay.
It's our motion, Judge.
Well, yeah, I understand that, Mr. O'Connor. I was just saying, was he, because there's
We have
two,
a second attorney on here, that's why.
yeah. Ms. Clifton?
This is case number 200036667 CZ Michigan Neurology and Spine Center versus State Farm.
Good afternoon, council appearances for the record.
Hi, Judge. Timothy O'Connor, the moving party representing State Farm.
Abdul Kareem Saad on behalf of Michigan Neurology and Spine Center, the plaintiff.
Okay, now I read this, you know, and we're talking about balanced bills, correct?
Yes, Judge.
And this is a partial SD, right?
It is because there are two bills that we denied because we didn't have enough information. So those bills were denied outright. So we're trying to carve out those particular two bills.
Okay, now, Mr. Stein, in terms of, I understand those two bills, correct me if I'm wrong, do they total 88,000? Is that right?
Their
Those two bills?
claim is for 88.
Okay, so the two bills that you're talking about, Mr. O'Connell,
They may be miscellaneous charges, Judge.
okay, so are you saying that the 88,000 that's referenced in plaintiff's complaint is balanced billing? All of it?
Absolutely. Absolutely.
Okay.
I have painstakingly gone through all of our payments. I spent the entire morning working on this. In their reply brief, paragraph 10, they said that there were 35 payments not made. And of those 35, the last two bills, February 27, 2020 and March 4, 2020, we had not yet received. 33 of the 35, we absolutely have paid. I have verified it, and I can represent to the court as an officer of the court that if we all look at the payment log attached as Exhibit 5 to our motion for summary disposition, I'm not asking you to go through everything here, Judge, but I can tell you that every one, because in plaintiff's reply brief, paragraph 10, he itemizes those dates of service that State Farm did not pay. And I can tell you that I've color coded, I've gone through, and I can tell you specifically, we have paid each of those except for those last two I just told you, Judge.
And what are those last two total?
Yeah, well.
I believe approximately $900. Is that correct?
Yeah, I won't argue with you, sir. If you say 900, I just know there are two bills that we didn't have yet.
Okay, so Mr. Saad, you've seen everything.
Yeah.
And I understand, you know, and I don't have a problem with it being in circuit court because, you know, it was removed from district court because it was assumed initially that they had a claim in excess of 25,000. So I don't have a problem keeping it here.
Okay.
I just want to make sure that we're on the same page. And, you know, as Mr. O'Connor has indicated, he went painstakingly through everything and has demonstrated where the payments were made on the majority of these.
And judges, I mean, we're not arguing that payment was not made, but just because payment was made doesn't mean it was reasonable. I mean, they're pointing to two cases, McGill and Lamuth, where they're two separate cases. For example, they're plaintiffs or patients who are suing, saying that 100% of the bill needs to be paid, or they're going to incur an injury. The court did not address whether the charges were reasonable or not. In McGill, the court actually rejects the plaintiff argument, saying if we were to accept the argument, which is that the insurance company is obligated to pay 100% of the bill, then we would be saying that the healthcare provider can unilaterally make a decision on what's reasonable. And if in this case, if you were to agree with the defendant, you would be doing the same thing, but saying that the defendant, State Farm Insurance, can unilaterally make a decision on what's reasonable. They're saying they made a payment, a partial payment, and that's reasonable, which doesn't make any sense. And then under Lamuth, the court actually addressed the issue where a healthcare provider doesn't believe that the termination of payment was reasonable, and they actually said here they anticipate the healthcare provider suing the insurance company directly through a third-party beneficiary theory. So just because they paid doesn't mean it's reasonable.
Okay.
If I may, so State Farm paid what it deemed was reasonable and necessary. The reasonable charge pursuant to MCL 500.3157. That is a cost containment provision within No Fault Act. And you might ask, well, where did they come up with the amounts they paid? Okay, Judge, all of the explanation of reviews are attached as Exhibit 4. Now, I think we didn't attach, I think there were maybe 100 of them. We attached a representative sample. There may be, 25, 30, whatever. All of those EORs, Judge, the EOR stands for explanation of review. Mm-hmm. It's like an EOB from Blue Cross Blue Shield. And on every one of those, it specifically articulates back to the provider, and they get a copy of every one of these. Michigan Neurology is a part of the Coventry network. And in those explanations back to the provider, I'm just going to say, if the bill is 100 and we paid 75, each time we did that, we sent out an EOR and we said that based upon this is the provider, the plaintiff, based upon your multi-plan auto provider contract as an affiliate network of the Coventry network, we have paid upon your agreement with Coventry. So this provider has a plan with Coventry, and we have paid pursuant to the Coventry dollar amounts. And each of those are identified in Exhibit 4, which is our EORs. And so, Judge, Mr. Nantroop, Gregory Nantroop, has not, nor will he ever incur any damages, because in those same EORs, copies go to the provider, in this case, Michigan Neurology, and to the insured, Mr. Nantroop. And we have articulated in those documents, based upon the insurance commissioner's recommendations, that we would defend and indemnify Mr. Nantroop against any balance bills claimed by this plaintiff. So Mr. Nantroop has not incurred any damages, nor will he, and we have paid pursuant to the Coventry network that the plaintiff, Michigan Neurology, belongs to. And it's for this reason, Judge, that our motion should be granted, but for those two bills that we have carved out specifically in our wherefore clause.
Okay.
Judge, if I could respond.
Mm-hmm. Yes.
Judge, first of all, I don't see in the defendant's motion any mention of Coventry, but I believe we did provide evidence that Michigan Neurology is not a part of Coventry. They haven't been a part of Coventry since November 17 of 2017. Additionally, there's a question of fact here of reasonableness. So the defendant doesn't meet his motion, doesn't meet the burden, or doesn't meet the does not meet the standard of review for this motion. So his motion should be denied for the reasons that I've stated.
Judge, I think the issue is not reasonableness, it's whether Mr. Nantrub would ever incur any damages. The plaintiff has no greater rights than does the patient who's obligated to pay that bill.
Okay, what about the fact that Mr. Side has indicated that Michigan Neurology is no longer part of Coventry since 2017?
Yep, and I wrote that down. Mr. Side, can you give me that date again? November 17, 2017?
Yes, sir.
Okay. This is the first I've heard of this, Judge. I don't have any information, documentation, or an end date of the Coventry contract. If what I'm suggesting, if as an officer of the court, Mr. Sade is saying this, maybe he can provide that to me and we can, I don't like moving things down the road or kicking the can down the road, but you ask a question, he made a statement, and I'd rather have all the details in front of us.
Mr. Side, how quickly can you get that information to Mr. O'Connell?
So what I do have is I have a letter from Michigan Neurology's PHO, which is the basically a PHO helps contract the provider with all the insurance companies, which would include Coventry, Multiplan, Cofinity. The letter states that Michigan Neurology nor the Dr. Shuedo in this case participates with any of those contracts through the PHO. I also additionally have,
Now, who is that letter from again?
PHO, Lake Huron PHO. So the additional, I do have an email from the Michigan Neurology's biller, an email from Coventry that Michigan Neurology's biller received that shows a termination date of 11/17/2017. And then additionally, we have proof from Multiplan that Michigan Neurology does not have a contract or doesn't participate with Multiplan. I can send those to him as soon as we're off this hearing now.
Okay, let me see how much time I'm gonna put this over. Give me a second. And if this can be resolved without returning, that's fine too, just let us know, but I'm gonna put this out for 2 weeks. Yeah, till October 8th, I think. Let me see. Maybe not. Let's do October. October 7th at 2:30.
October 7th at 2:30.
Yes, and like I said, Mr. Side, you're gonna get 10, 7, and 2:30. You're gonna get that information to Mr. O'Connell, hopefully before the end of the day today.
Yeah, we're gonna send those to him as soon as possible.
Well, can we, in Mr. Sade, whatever time you need, I'm just trying to put an end date because Judge, you bring us back in a short bit of time. I want to make sure I have those documents as soon as possible.
Right, so Mr. Side, you need to get those documents to him by close of business tomorrow at the latest.
We'll get them to him today.
Okay.
Thank you very much.
Okay, so we'll see you on the 7th at 2:30.
All right, appreciate it.
Judge,
Thank you.
do you need a reprecipe or is it just you
No.
telling us and we're just individually put it on our calendars?
Put it on your calendar. This is a continuation.
Okay, Judge, thank you and have a nice day.
Thank you.
Appreciate it.
Okay.
Thank you.
Bye-bye.
Bye-bye.